Kupina kuphe emakhaya emadolobheni aseComplus khona lapho ubukela khona SABC 1 sakumukela ke mbukele siphinde sikumukele futhi ehlelweni lakho lamhla ilungelo lakho it's your right silethela ke lihlelo lapho ke SABC 1 eMzansi for sure mina ke ngisimpiwe Ngcongwane namhla ke sibhekene nenzaba mlonyeni abathengi labadibana nayo leyo ke yokudlelwa ke tindlu ngenzaba yokuthi ke bangemuva ekhokheleni Levy fees kuma complex lebahlala kuwo. So at what stage can a body corporate attach your property for owing levies? Athini ke amalungelo akho kulelo hlangothi Vuyisela Mdoda kusilethela ke nayindzaba yemndeni waseJozi lobhekene ke nekudlelwa likhaya yi-body corporate.
uSharon Williams akakholelwa ukuba indlu ayithenga ngo-1998 wayihlawula ayigqiba ngoku ayiseko phansi kwegama lakhe waphulukana nayo mhla yathengiswa kwifandisi i-auction ngolwasemzini. Amaxwebhu aphathelele ekuthengisweni kwayo athi kwinxa yetyala lokusilela ekubhataleni imali esisinyanzelo ngenyanga i-levy ngolwasemzini.
They auctioned the property. I don't know for what reason. They said we were outstanding with 5,000. And so these people, they auctioned the house for the 5,000. We've been running around to legal aid for 6 years. They've been doing nothing. Didn't help us, nothing. Every time when we go there, they've got a story.
Williams uthi indlela aphulukene ngayo nayo lendlu inonyawo lomfene. Akayiphiki into yokuba wayesemva ngemali ehlawulwa qho ngenyanga kodwa wazama ukukhawulelana nalo meko ngokufumana umntu wokuqesha apho. Uthi akayazi uba kutheni i-body corporate yaqhubekeka nokuthengiswa kwayo nangoku sekho abantu abahlawulayo.
We had some tenants in the house. The house was empty for a year. That's when I moved back to my parents because my mother got ill. She got sick and I had to go and look after her. So the tenants were staying there. They did pay. Now they auctioned the house because they said we were still owing the bond. But we never owed the bond. The bond was paid up.
Omnye wabantu bachaphazelekayo kwingxaki kaSharon Williams nguThenjiwe Mnguni. Yena wafika indlu kaWilliams isecicini lokuba ithengiswe. Uthi wazama ukunqanda ngokuthi aqeshe kuyo.
So mangithi ngiyorenta ngathola ama-summons ukuthi indlu yakhe izo-auction. Ngaqala ukudiga information ngoba ngiyawazi umthetho wama-property. Ngitrainiwe ngomthetho. So ngathi ngizobasiza ukuthi sibheke ukuthi yini into e-wrong. Ukuthi ingalungiseka kanjani lento. Masithi sakhulumisana nama-lawyer ne-managing agent. Bathi no bona abafuna ukukhuluma abafuna ukudla lendlu. Ngadonsa ama-document. So ngakhuluma no-Mr. Williams ukuthi Mr. Williams kunama-summons lana fanele sibheke ukuthi ahamba kanjani lama-summons. Ngathi ngizobhadala ke i-5,000 every month ku-body corporate ukuthi sizame ukustopa lama-auction. Bala ilokuzeni i-managing agent nama-trustees ukuze ayenze lento kufanele asebenze sibiza ukuthi ngama-foot soldiers, people from inside ukuthi basebenzisane naye ngoba yena nje maye ngaphandla kanama-power so udinga abantu bangaphakathi. Fanele asebenzisane nabantu bangaphakathi aba-involved ku-corruption hayi wonke ama-trustees labo aba-involved ku-corruption.
KwaMnguni uthi wazama ukuyihlangula lendlu ngokubhatala ngaphezu koko bekufuneka kodwa onke oko zange kwenze mahluko. Kusenzeka konke oku uthi akasenambane namanzi. Ngomthetho inkundla yamatyala kuphela inika umyalelo wokucinyelwa amanzi okanye umbane.
Ikhona i-court order ethi gas ngocinyo.
Abanayo laba abantu abasebenzi ngomthetho abana court order ukucima ugesi. Bayazenzela.
Ngoku Williams uthi ufuna indlu yakhe ibuyele kuye kuba uthi i-body corporate ayilandelanga mthetho izenzele. Ingabe ingxaki eqala ngemali yephansi iyakwazi uba neziphumo ezifikileyo ekuthengisweni kwendlu. Awuzibona kwimeko engene kwemali. Leliphi inyathelo elibalulekileyo kufuneka ulithathe khona ukuze uphephe isehlo esifana nesi. Vuyisela Mdoda, ilungelo lakho.
Sibonga lo mbiko kulijala elikhulu lapha ke kuVuyisile Mjola. Manje ukukhuluma kabanti ngale ndzaba ke sesimukele ke Advocate Boyce Mkhize lovela ke Community Schemes Ombudsman Service. Sinaye ke sinaye ke Rudy Heshop. Yena ke uvela lapha ke singathi ke ungummeli specializing in debt collection. Gentlemen, a very good afternoon to you. Thank you so much for joining us. Welcome.
Yeah, pleasure.
All right, great stuff. Rudy, I'm going to start with you. First of all, what's the financial duty of a body corporate?
Well, the thing is, if you consider the Sectional Title Schemes Management Act, the first power, the first function of a body corporate is to establish and maintain administrative fund and a reserve fund. So the money is the lifeline of any business. It is the same thing for a body corporate. So this is what the legislator said. The first thing that we need to establish is the money. What is the budget? Make sure that your members contribute, have a sufficient budget for the administrative fund and for the reserve fund. So that's the essential of the lifeblood of a body corporate is the funds.
But what does the law say then with regards to the body corporate attaching homes, because the homeowners owing levies? I mean, if you consider the insert that we've just seen, they were owing levies to the tune of 6,000 Rand and then they lost a home.
Look, I don't know the facts of the matter. I don't know all the facts.
But does a body corporate have the legal right to attach property?
Yes, this is where I want to go.
Okay.
So every member is obligated to contribute towards the administrative fund and the reserve fund of the scheme. The members, in fact, vote upon this budget. At the AGM, the budget is approved, and this is, like I said, the lifeblood of a scheme.
Yes.
At any stage, when you fall into arrears, the scheme has got a duty, in fact, the trustees, to ensure compliance with the rules and with the budget. So the scheme executive and or the managing agent, if so duly authorised, may then institute the necessary proceedings.
Okay.
Now, the question that you pose is, when can a property be attached? That's a different thing. So in certain matters we've had where judges and magistrates say, you must first execute and you can't just sell a property for about 5,000 Rand as per the insert. But we've also established that in certain instances where a property was sold for 10,000 Rand in arrears, it's a discretionary function of the court that can decide on whether or not the property to be sold. But it's also not that simple. You need to look at whether the property is a primary resident property or whether it's a secondary property. So if I have a holiday home, now I don't pay my levies. So why shouldn't the body corporate be entitled to sell my holiday luxury home for arrear levies of 10,000 Rand? And also what needs to be considered, and this is what people forget, albeit that we proceed with the collection of the matter in month 1 or when you 10,000 in arrears, to get an execution order on a property is not a simple process. It is not a quick process. So from there till up until the date of judgment where we can actually auction off the property, that's a time period of about 2 years passing. So when we go to court, your arrears, albeit that we have judgment for 5,000 Rand or 10,000 Rand, at that stage, together with the interest and legal fees and so forth, that amount can easily be 100,000, 150,000, which the scheme is out of pocket.
But then who gives the body corporate the right to attach a home? I mean, can't they attach other assets such as a car or movable goods, furniture? Why? Why would they target a house?
Okay, so it's not that simple again. As I said, this is a process. For us to execute upon your property, we need to follow due process.
Yes.
One of the processes in the High Court is we need to obtain a nulla bono return of service. What that means is you don't have sufficient movable assets to actually pay towards the debt. So even after I've taken all your movable assets, there's still debt outstanding.
Yeah.
So for us as attorneys and for the body corporate, there's an obligation to first try and execute on your movables. And if we can't, then we can approach court for an attachment order. So it's not a simple process.
Right. Granted. Now, Mkhize Kabazele, let me also bring you into this conversation. What's your view from the position of the ombudsman, with regards to who has the legal right to attach what property and what the financial duty is of a body corporate?
Well, first of all, thanks for having us. As the Community Schemes Ombuds Service, our role is to ensure what we call alternative dispute resolution. And that is to try and mediate problems and issues such as this one that we saw in the insert. And in doing so, we try and put together the parties so that they can try and resolve the problems and the disputes and the complaints or concerns that they may have with, little formalities as is possible. And also without having to engage in very expensive expeditions such as, your hefty legal costs that are normally attendant to these processes. And it is the duty of the body corporate to ensure, and the Board of Trustees, in terms of the memorandum of incorporation of that particular body corporate or whatever founding documents of that particular entity, to actually manage the funds for the benefit of the scheme and for the benefit of all members. And part of that includes the responsibility to collect levies from everyone from whom it is due. Now, it does appear a bit anomalous for a debt as little as this one to actually have a situation where the entire house, which would be valued at much higher value than that, gets to be attached. One of the issues that we have been trying to inculcate in terms of the body corporates and the Board of Trustees and managing agents is this idea that they should always try and foster what we call social justice.
Yeah.
Social justice basically means that you need to be humane in your approach in terms of management. It simply means take into account the issues that may be affecting the other side and find the least adverse mechanisms to actually try and resolve the issue.
Yeah.
I mean, 5,000 rand with some repayment arrangements is really neither here nor there. It's something that could have been instituted, in my view. Obviously, we need to look into the facts of the matter, in totality, and see what exactly happened or transpired there.
I mean,
But
being deprived of a home and shelter is a basic human right violation. I mean, I'm going to pose the same question to you. Ukuthi-ke, ngubani ke lo niketa-ke i-body corporate lungelo leku-attacha umuti instead of looking at other assets, njengetimoto noma furniture, or just about any other assets that the homeowners may own?
Yeah, well, I mean, the body corporate is vested with the authority in terms of the law. Now, so what then happens is that the body corporate becomes what we can call a creditor, okay? And the person that owes becomes a debtor. So any creditor in terms of the law is entitled to actually enforce processes that will give rise to them collecting what is due and owed to them. And they do so on behalf of the rest of the members of that particular scheme. So by law, they are entitled to do that. And by law, they are entitled to actually go ahead to actually do the claim. Rudy is correct. So once they can satisfy the court that there is nothing in terms of movable assets, etc., or loose assets that would actually satisfy the debt, they would then be entitled to go for something as extraordinary as attaching the property, so that they can satisfy the debt. So that authority vests in them in terms of the law, but also in the bigger scheme of things, every member that subscribes and signs up to live in the scheme subscribes to the rules of the body corporate, which rules must in fact also include the fact that the levies must be paid. Sometimes there's a normal levy, sometimes there's a special levy that is imposed. We get concerned where there are no engagement processes to ensure that the enforcement of those things in fact is informed by consensus and by democratic processes of decision making.
Right, that's a very valid point, and I want us to pick up on that point after the break. Please do join us after this break. Yilungelo Lakho. Sakumola futhi ngibukele tincingo traffic ativuliwe ukuthi ke nawe ungaba ingcenye yale nkulumo yethu namhla ungasishayela ke ucingo ke ku 0608449857. Well, it's a new number that we're using. We're not using the 011 number today, but you can use the number on your screen right now, 0608449857. 9857. Ungaphinza kusithumele uthinzeke na ku Facebook or Twitter. Namhla ke sikhuluma ke malungelo akho ke nangabe ke uhlala ku complex ke udila ne body corporate. Nangabe ke i body corporate ifuna ke kudla noma ke ithengise noma ke auction umnti wakho ngenzaba ukuthi uya owa noma ke ungemuva ngema levy fees. Kuthi ke athini amalungelo akho kulelo hlangothi. Now boys, I want us to talk about your office, the office of the ombudsman. Kuthi is it really the court of last instance, or an aggrieved homeowner, can they run to you and then you can make a decision against the body corporate? No, banga auction lo muti.
More often than not, aggrieved homeowners do run to the CISOs for relief, and we obviously evaluate the issues, and we would grant an order that is suitable, judging the matter based on the evidence that's available before us.
Yeah.
And sometimes it has to do with the issue of the calculation of levies, the calculation of what is owing and due. Sometimes it has to be compounded by issues of interest that gets added on, etc. So we've had to intervene in some of these issues. We're not supposed to be the court of last instance. We're supposed to be the first port of call. In fact, this has been confirmed in judgments of the High Courts of South Africa, where they have said disputes that relate to scheme governance issues and that flow from the Sectional Titles Schemes Management Act ought to be first adjudicated by the CISOs. And so our call is to actually say, if there are issues of concern within the body corporate, members should not wait until it is too late. When you get to the point, I mean, to attach a property, like Rudy was saying earlier on, is not just an overnight process. So these things grind over time, and we do want to say people should not take these things for granted. They must rise at the earliest available opportunity as they see that, the water is proverbially coming into the house. So they need to make sure that these issues are canvassed at an appropriate time. And we are able to intervene in certain instances. We have, in fact, in some instances, issued orders where we said this calculation of the levies is incorrect. We have issued orders in some instances where we said the very composition of this levy was not informed by a consultative process that was necessary to arrive at this levy.
Right.
So those are the kind of orders that sometimes we issue. And it is all about ensuring there is proper and good governance and that there is transparency in the manner in which the funds of the scheme are being managed and applied.
Okay. Now, Rudy, how much do I have to owe the body corporate in levy fees for the body corporate to attach my immovable property, such as a house? I mean, is there a minimum or a maximum value?
No, technically speaking, there's not, but it will be informed by the facts. As I mentioned previously, the sale of your property is a discretionary function of our courts. We normally refer the matters to the High Court, and then a judge will look at all the surrounding facts. Like I said, if it's your luxury second home, there will be an issue for you. But if it's your primary resident and I've got judgment for 5,000 rand, the members pitch up at court and they propose to the judge a payment plan. That judge will then send us back to the office and will not grant the execution order. So there's various factors, but to answer you, no, there's no minimum.
So what's the one common mistake that people make, I mean, leading to such issues as this?
Being difficult.
Being difficult in what sense?
Having a high-handed approach towards your scheme, not accepting that you're part of a community scheme,
right,
and not accepting your liability. As I mentioned previously, this is a voluntary association, for one, that was established. This is a sectional title. You bought into the scheme and there's certain rules applicable. There was an AGM where the members voted upon a budget. Now, you must understand that the budget is an itemized thing voted upon by the members. It's not a profit company. So as soon as one member doesn't pay his levies, what now? The rest of the members needs to subsidize that member. Alternatively, we take money from the reserve fund. That was catered for maintenance on the roof. Now we can't do maintenance because you're not paying your levy. So there's a flip side to the coin. So it's not just this credit to the body corporate. They're trying to enforce and trying to sell your property. there is an obligation upon the trustees to look after everybody in the scheme and utilize the money for the benefit of all the members. So you not paying your levies has got a serious ripple effect on the scheme. And I've seen instances where there's not levies being paid, the scheme then decides not to pay the insurance at the end of the month, and something happens. What then? You understand? Then it's to the detriment of all the members because you didn't pay your levy.
Got you. Now, boys, do you want to weigh in on that?
Yeah, no, I think Rudy is correct. I mean, part of the reason is that, you know, people sometimes do get difficult, and that's the nature of things. You become defensive, and these things naturally, you know, get to a point where they gravitate to a point where, you know, it's, wheels off the rail, and the body corporate is left with no option but to go and enforce, you know, its rights. In defense of everyone. Remember, the issue here is that it shouldn't be any free riders. That's number one. Number two, you actually commit by subscribing to become a member of the scheme and purchasing in that scheme, that you would actually abide by all the rules and the prescriptions of that particular body corporate. So in short, abantu bakithi sometimes bayahluleka ukuthi bathi yabona manje angisakwazi angisakhoni ukuthi ngi-afford le ndawo.
Okay, I get that. I mean, granted,
afford le ndawo, thola indlela yokuthi le ndlu mayidayiswe uyothola enye indawo la ungahlala khona engezukudinga lama levy lawa afunakalayo. So le nto izokusiza ukuthi ungabi kule nkinga yokuthi udlele indlu ngo-5,000 rand. So part of the issue is to actually being part of that. The second issue, which is a problem, ukuthi asiyi emhlanganweni lebiziwe ebizwa ama-body corporate ukuthi siyozizwela ngakwethu ukuthi i-budget yona ithini, yona le budget le yenziwa yini, yona le budget inaziphi izinto nezinhlaka okufanele zisupport. So all of those things make issues difficult for the management of the body corporate structures. Meetings hardly ever form quorum in AGMs in terms of the body corporate schemes. They hardly are able to actually sustain those quorums in the meetings because people just simply don't take interest.
Emma, decisions, are they not communicated in writing through email or whatever? Decisions made or
well, the
those
decision
AGMs?
must not be made on behalf of the members. The decision must be made by members.
By the members, yes.
And so they cannot be a situation where decisions are just taken at a particular level without the involvement of the members.
Okay.
So this is why this is a very important point around democratization of the schemes and ensuring that the governance structures are appropriate, that there's transparency, there's free flow of information. We've seen a number of managing agents, and some of them, in fact, on some of the structures that in fact refuse to share information about what informs the special levies, what is it that informs some of the expenditure, what are the bank accounts saying in terms of the reflections of the income versus expenditure and all of those issues. We insist that they should actually be transparent. People are entitled to that information.
Please hold the thoughts. Let's take our first caller. Sina Musuthu lapha ke Pitoli sakumele ehleni saboda. Siyaphila kunjani baba? Khuluma nathi baba, what's on your mind?
Ngifuna ukwazi kahle kahle i-body corporate ukuthi i-flat rate yabo monthly malini, because corporate seems to fluctuate esiding la.
Come again, baba. The line is not the best. Cela uphinze umuntu wakho baba.
Ngifuna ukwazi i-flat rate body corporate yama-flat asePitoli, because sometimes it fluctuates and I can't get the real answer. You get my point?
Okay.
Yeah.
All right, Musuthu. Thanks for the call. Thank you so much for calling us. We'll definitely take your answer after the break. We are back after this. Welcome back. Our participation lines are now open. You can now call us on 011-714-0669 or 011-714-0670. I'll repeat the lines again. Our 011 number is back and it's on your screens right now. It's 011-714-0669 or 0117140670 to take part. The number, cell phone number is also on your screen. You can use that number 060-844-9857. You know, when you're in a situation where the body corporate is attaching your property for levy arrears, and noma kudlela ke umuntu body corporate yakho noma ke sokoleta malini emalevy athina amalungelo akho. That's our question. That's the gist of our discussion today. Now, Mkize Kabazela, before we went to that break, we had Msutu before on the line from Pretoria. Ubuta ukuthi ikhona i flat rate kuma levies.
Cha, ayikho flat rate kuma levies. I levy iyahlukahlukana ngokwama schemes ahlukene. So ama members ayahlangana athi nansi levy thina ezivumelana ngayo ukuthi kufanele i-collectwe la in this particular scheme. So those vary from one scheme to another. At certain times, the body corporate would, in fact, decide we need to increase our levy to attend to a special project. For example, there's a big maintenance issue that has arisen within the scheme, and they require, extra cash. And that's where you hear, for example, of something called special levies, etc. So sometimes the levies would increase, sometimes they would be adjusted, just in terms of inflation, etc. So you wouldn't have a flat rate. Scheme 1 and Scheme 2 may have two different sets of levies. So there's nothing called a flat rate. Obviously, the participation quota, which is called the PQ, also influences and informs the determination of those levies. This basically is dependent on how much stand that you occupy and how much land you occupy within the scheme, etc., just to ensure that there is equity in terms of the distribution.
Okay.
But generally, there isn't a flat rate.
All right. Rudy, your thoughts?
No, I agree.
Yeah.
There's no flat rate when it comes to levies. It's calculated in terms of the Act by way of participation quota. So, i.e., if I've got a bigger stand, my levies will be calculated at a higher rate than that of the smallest stand. So it is a percentage out of 100. You'll get your budget, which the body corporate needs for the next financial year. You will then take the participation quota, divide it between the members, and that's what they pay.
Okay.
So it is for equality within the scheme.
Okay, let me pick your brain on this. Are body corporates open to supporting a homeowner in terms of, requesting more time to address their financial difficulties?
It depends. It depends on the restrictions imposed upon the trustees. I normally advise my clients when I deal with them that there needs to be a collection policy agreed upon. It shouldn't be the trustees who agree upon it, it should be the members that state that there's certain rules pertaining to debtors. Obviously, what I also say to my clients is that money in the bank is better than not.
Okay.
So if somebody approaches you and he says, well, I fell in arrears, I'm willing to catch up the arrears, enter into a settlement plan, a payment plan with you, I'll pay my arrears in 6 months, but over and above that, I will contribute monthly towards my levies.
Okay.
I advise my client to accept that, but that is a payment plan. That is not a right. And this is what we get a lot. As soon as it's proposed, it is within the discretion of the trustees to then decide whether they want to take it or not. It's a privilege when there's a payment plan and not a right.
All right, let's take our next caller. Sina Emily ulapha ke Protea North. Siyabonga ehleleni sawubona. Siphilile kunjani mama?
Ngiyaphila.
Khuluma nathi mama.
Okay, mina ngicela ukunceda kapha ngidana ngithenge indlu nge-2020 nesicela ukufana kule ndlu ngoNovember 2020. Indlu siyithengile sicela beyithengiswa umuntu but sayithenga through agent. So lo agent makaqeda ukunikeza isikhiya wasitshela ukuthi igesi sizothola nje iletha izositshela ukuthi sibhadala malini because asiyi-prepaid lela igesi eleyakudala kwi-statement. So until now, akuna-statement. Ngizabe kuhlangana nozweli lo agent asithengisela ukuthi angithola i-statement wathi ngifonela amaloya lawa beba-involve kule ndlu bayithengisa. Amaloya ngibathengela ama-email amaningi abaphenduli, so angazi ukuthi elekezeni because eskhoma akafika la elilanga uzocima mina angazi. Ngaya la emidweni ngayithi ngibhalisa igesi, bangifika-ke emidweni bathi akusetshenzwa ngisiya igama bazangifonela. Nabo today abakazi bangifonele imidweni angazi ukuthi ngekangaki. Ngaya eBranton ngathola ukuthi esithile lapho, so angisazi ukuthi ngingedekala kuphi.
So basolo bangakuthumela i-statement sekuthi malini?
Asikakazifike.
So manje bathi bafuna ku-attach lo muntu?
No, abakafuni laba ngifuna uncedo ukuthi ngiyenza kanjani because angifuni ukuhlahla sebozothatha umuntu because ngikolota igesi. Ngifuna nje ukuthi ngithole uncedo before kufika kule stage. Because ngihleli igesi ngiyalisebenzisa but akuna-statement sibuyayo.
Okay. All right. Emily, thank you so much for your call. Sama ukhulu kushayela. Ungathatha ukumphendula mkhize.
No, ngathi inkinga kagesi. Inkinga kagesi ikakhulukazi iphathelene nomasipala. So kungcono ukuthi umama ayobonana nomasipala ngokuthola ama statement ukuthi ugesi uhamba kanjani. Akusiyona into kakhulukazi ye-body corporate more than it is a municipal issue, so that she can then get some help from the municipality.
All right. Now, Rudy, suppose that the border corporate applies to court to attach either my movable or immovable property, and you and I know that such a process could drag on for months and possibly years. So what then happens to my duty to pay my levies?
It never stops. While you are a member of the scheme, there's a statutory obligation upon you to comply with the rules.
So I should continue paying my levies even though I know that my head is on the chopping block?
Yes. You're eventually going to pay. That's the thing. So when we sell the property, that debt needs to be satisfied before transfer can take place.
No, but the argument is, why am I paying? Because I know I'm going to lose the home in any case.
Perhaps you're not going to lose it. The obligation remains. So in terms of the Act, I can't refund money. The trustees can't refund anybody levies. It can't write off levies pertaining to somebody.
Yeah.
So, as I mentioned, the statutory obligation upon them to enforce that obligation remains. While you're part of a member of a body corporate and or a homeowners association, you must comply with the rules, which will include your duty to make payment of your monthly levies.
Okay, say the home is bonded, like I'm paying a bond for this loan, and then the border corporate, for this home, and then the border corporate gets a court order to attach my property. What then happens to the bank? Because it is, in a sense, owned by the bank, isn't it?
Look, the bank's bond is security over your property. We cannot just sell the property, or the body corporate can't just sell the property without the intervention of the bank. So what will normally happen is, upon receipt of the order, we as the attorneys acting on behalf of the body corporate will then inform all the banks of this judgment. We will inform the banks of the auction date, and they will send a representative to the auction. The auctioneer, if there's a bond, needs the consent of the bank to actually conclude the sale agreement. That is if you have an auction sale from a magistrate's court. If you get the right to sell a property in the High Court, if the bank does not comply with our request for a certificate of balance or fails to come to the actual auction, the sheriff will then be entitled to sell that property without any intervention with the banks whatsoever. So the banks are also at risk if it is a High Court order. But we need to consider them. There's an obligation upon me to inform them that this property will go on auction, and 9 out of the 10 times they will send a representative to the
So basically,
auction.
of all the three parties, it's the body corporate that wins because the bank loses and the homeowner loses.
Look, normally when you can't afford your levies, normally you don't pay your bond. We've seen that throughout. So it is, we've also seen that it's a race where the banks actually proceed with matters, we proceed with matters, and as soon as there's judgment, we realize we're chasing the same debtor. Albeit that our cause of action is premised upon levies, their cause of action is premised upon non-payment of the bond, but it relates to the same property.
All right, we'll continue this discussion in a moment. Mbugeli, let's take another break. As Prince Stebane gonna swear at Leli, Yilungelo Lakho. So kumele futhi ngibukele khumbula ukuthi nawe ungaba ingcenye enkulumo yethu namhlanje kusishayela licingo ke ku 0608449857. The number is on the screen right now, 0608449857. Namhlanje sikhuluma ngamalungelo akho nangabe ke ibody corporate seyihlongota ukuthengisa noma ke ku-auctiona umuntu wakho ngenza bakuthi ke usemuva ngema arrears noma ke ema levy fees ukuthi ke yini lokumele ukuthi ukwende kuloko nekuthi amalungelo akho athini. Now Rudy, I want us to continue with the issue of assistance being extended to the homeowners who face their homes being auctioned. Can a homeowner reach a settlement with a body corporate in terms of paying the outstanding amount in arrears or installment or whatever that they can afford to pay at that particular time, rather than the body corporate running to court?
Yes. So I want to take a step back. Before I actually go to court, I need to send a statutory letter of demand if you stay within a body corporate. So statute places obligation upon me to inform you that I am going to institute proceedings against you. What we encourage the members then is to approach us, is to approach the managing agent and to approach the trustees to settle this matter, rather than this matter getting out of hand. Because if you leave the situation and you don't actually act upon a member not paying, you're going to create a situation where if you hand that member over, you'll in any event not be able to pay. So I normally advise trustees and managing agents to, as soon as 30 days in arrears, even 60 days in arrears, make contact with this member and try and get a plan. Don't allow this member to get in arrears with 10,000 Rand, because you're creating a situation where I will be forced to actually execute upon your movable, if not your immovable property. So the sooner that you fall into arrears, unable to pay, contact your scheme executive, contact your managing agent and say, please, this is my situation, play open cards, but just don't abstain from communication. If an attorney phones you, communicate with the attorney. Because for us to approach court, we need to comply with statutory obligation. The scheme needs to comply with statutory obligation. There needs to be a meeting. There needs to be an approved budget. I need the minutes of the meeting. I need the attendance register of the meeting. I need to prove that everything is compliant before I proceed. So in 9 out of the 10 times, it is compliant. Then I proceed to court. But I inform you, I write you a letter. I then send the sheriff to your property with a summons. In that summons, I say, contact my officers. I pointed out that if you're going to file and continue with this manner, it might be a possibility that I'm going to sell your property. So a lot of the people think it is just a bark with no bite. And the thing is, I want to say to people, be careful. You've got a right to pay. There's an obligation upon you to make payments of your levies. And if you want to enter into a payment plan, you can't just dictate at the end of the day if you 10,000 Rand in arrears and say, well, I'll pay 100 Rand a month. The problem with that scenario is there's still current levies. So your 100 Rand a month will not cover the monthly levies.
What if that's all they can afford?
That's the issue. Then they need to sell.
Sure. That's a bitter pill to swallow.
It is difficult, and it's never good advice, or it's advice that doesn't sit well with me, because we say to people, if you can't afford, if you can't make a plan, why are you part of this? If you can't drive a BMW M3, then sell it. So why purchase a thing? Yes, at the time you could afford it, but the time that you can't afford it, don't hold on to it, because it's going to get you in trouble.
Yo, kids, we are familiar now.
My brother, it's as simple as all that. You're part of the scheme, you've enlisted, and what the CSOS is not going to do is to actually give you a reprieve in terms of saying, well, you're under no obligation anymore to actually service your debt in terms of the thing. What we do look into is the fairness of the process around the determination of the levies, number one, and the fairness around the accuracy of the levies and the statement and that which is due and the computations around that. But we will never interfere at any stage with the obligation to pay and to service your debt in relation to the levies. And that's why it is sound advice to actually look into your own financial situation. Am I still in a position to afford this environment in which I live? And, you know, people do downgrade, people do change lifestyles based on different circumstances. It's sound advice. Rather than obtaining a judgment against you, rather than being blacklisted, rather than having your property being attached. I mean, if you sold this property yourself, you could make some money and be able to, you know, go elsewhere. But the fact of the matter is that you signed up to be part of the body corporate, and because of that, there are certain rules and obligations that arise out of that membership.
But then should the CISO's processes be exhausted first, or can a body corporate run to court to collect outstanding levies?
Well, more often than not, they do. But the general counsel is that the CISOs should be approached first to mediate and resolve these kind of disputes. In fact, some of the matters that have gone to court prematurely have had to be reverted back to the CISOs. And so, I mean, our call to body corporates and scheme members is to always, you know, start with the CISOs so that they can find better, easier, and cheaper resolution of their disputes. Because our approach is not adversarial. We have what we call a conciliation process, where we engage and make the two parties to engage. Why is it that it's difficult for you to acknowledge the debt in the first place? How did the debt arise? What is it that would constitute an acceptable arrangement? Okay. Those kind of things, so that the parties can then come to a settlement agreement. It becomes a win-win situation. If they fail to reach that settlement, only then do we escalate to the next stage, which is called adjudication. That one is more like a court process where we have to issue an adjudication order which has got the strength of a high court order. It can only be set aside by a court, by the high court. Okay. So we encourage people to come to the CISOs to get those resolution, get speedier resolution, get cheaper resolution. In that way, we're able to live peacefully within the communities, because that's the ultimate aim. When all has been said and done, these people must be able to live and coexist peacefully within those particular schemes. And that's why it becomes paramount for us to try and create sound and lasting relationships amongst the members of the scheme and the body corporates. Okay. You raised an issue about the other members coming to the aid of the other member. Now, here is the issue about that. The members of the scheme are, in fact, the ultimate authority in relation to what happens and goes on in terms of that scheme. Of course, within the parameters of the law. Now, what is important is that when there is an AGM, and Rudy spoke about the collection policy and whatever other founding documents of the scheme and the rules of the scheme, those need to be adhered to. And there are certain resolutions that members would be competent to make. Okay. For example, we've had COVID, and they say, let's try and reduce.
We really need to take this caller. Sure. We've got Tiamo ulapha ke Soweto sakumoto endleleni sawubona.
Hi, but how are you?
Very well. How are you, Tiamo?
I'm good, thanks.
Good stuff.
I just have a quick one. What I wanted to find out is, what does one do when you realize that the body corporate, or should I say the company of the body corporate, has been deregistered?
Oh, okay, okay. That's a very good question. We'll get your answer after the break. We have to take a break. But thank you so much for your call, Tiamo. Tiamo there is in Soweto, and she's asking what to do if the company under which the body corporate reports to has been deregistered. More on this and others after the break. Yilungelo, Lakho. Welcome to a very final segment. Saqhuba futhi nenzaba yethu namhla ke ngenzaba imalungelo akho nangabe ibody corporate ifuna ke noma ke sevele sewuthengisile umuntu wakho ngenzaba ekuthi wena ke awukhona ukubhadala levies noma ke arrears. We had a caller, Tiamo from Soweto, and I want both of you gentlemen to maybe, weigh in on this. She's asking what to do if a body corporate has been deregistered. Have you come across such?
No. A body corporate, and as I understood the question, she referred to the body corporate as a company. So firstly, a body corporate sectional title scheme is a statutory body created by statute. So it's a separate legal entity registered at the deeds office. So it's not a company that you put in the registration number, you get a deeds office register number, and that is your number. So you can't deregister a body corporate unless she wasn't clear with understanding of the issues pertaining to the deregistration, but you can't deregister as you would deregister a company. It's not applicable to a sectional title scheme.
Okay, Mkhize, have you come across such a case?
No, not at all.
Okay.
I mean, Rudy is right. So you're looking more like a common law association, as it were. But obviously, this is now statutorily driven. So every member within that, it's a proclamation of the scheme that basically gets to be gazetted and all of those things, and it gets to be registered as such.
Okay.
So you wouldn't have a situation where, I mean, unless the entire thing just collapsed and, you know, whatever. But, I mean, one will never come across situations. We have never come across situations like that.
Okay,
Perhaps
say
he's
a
mistaking
homeowner.
business.
Yeah, in closing, say a homeowner is faced with his or her home being auctioned to pay off outstanding levies. What should they do?
Well, the first thing is to step up and own up. You know, do you owe, don't you owe? Has there been a miscalculation? Show proof. Is there a mistake? How did it arise, etc.? Show proof of payments, if there's any, etc. If you're owing and you haven't paid, own up. And
But if Yilungelo, do they run to court or they run to the office of the ombudsman?
Essentially, what they ought to be doing, and we encourage members to actually resolve the issues within the scheme before they run out to external tribunals, because essentially this is about ensuring that there is order and peace and stability within the schemes. So they must deal with the issues of what they owe, and they must work out a payment arrangement. If they can't settle the debt all at once, what are the payment arrangements that they could come up to, which are reasonable and sensible? And once they have done that, they must stick to the repayment arrangements. If there is a dispute,
we're out of time,
they come to the CISOs.
Rudy, just a quick one. Your words of advice for people who are facing their homes being auctioned off, just briefly.
Immediately contact the attorney and enter into a payment arrangement.
Okay.
And don't have a high-handed approach.
All right, gentlemen, great chatting to you. Thank you so much for joining us.
Thank you.
Great stuff. Kwanyaloke Mbukeli, sasifike emaphethelweni ehlelo lethu namhla. Let me thank our guests for making time to be with us on the show. Ngithazaboka kanye nani ke babukele ngekuba nathi kuze kube manje asihlangana futhi ke ngesikhathi lesitako lapho ke sitaba sinilethela ke lenye ke indzaba lethinza wena nemalungelo akho njengemthengi. From Miss Mphiwe Ngongwane and the rest of the team, sizikenisela kahle, wishing you a great week ahead. Cheers.